Right now, some potentially damaging testimony in a hearing for two men accused of a crime, grabbing the nation's attention more than a year ago. The senseless beating of a fan outside Dodger Stadium on Major League Baseball's opening day, leaving Brian Stowe, the man on your screen there, a father of two, with permanent brain damage. Now, the sister of one man accused in the crime, who's also the girlfriend of the other man charged, says one of the suspects had a bloody hand as he ran back to their car. That's one of the important testimonies that we've heard of these last couple of days of preliminary hearings. Our legal panel, defense attorney Chip Merlin's with us, and Donald Schweitzer, a former prosecutor and police officer. So, Donald, this is the fifth day of preliminary hearings. Is that typical? Does it seem like they have enough to go to an actual trial?
Well, there should not be a trial if the defense has its way, Jenna. There's a mountain of evidence against these defendants, and these attorneys should be begging and pleading with the prosecution to not take it to trial. They need to get a deal. This evidence that you've just seen with the suspect's sister, Doreen Sanchez, goes a little bit further than just saying that she saw them get in the car. She heard her brother turn around and say to his son, "Don't tell mom about this." This is very, very damaging to the defendants, and they're looking at the maximum sentence under California law because of the nature of the injuries in this case.
And what would the maximum
think that it's going to go to trial.
By the way, Donald, the charges right now, mayhem and assault charges. So if this does go to trial, what potentially are the men on the screen looking at?
The upper sentence for mayhem is 8 years in California. And don't forget that these are strikes. And I don't know anything about their backgrounds, but if they have any prior criminal convictions, it could be even worse than that.
Chip, what do you think about this? What do you think what Donald has to say, that really the defense right now needs to start working on a deal?
Well, I don't know about this. This is a preliminary hearing, and what we're actually finding out is that there are a lot of people that were wearing Dodger shirts that night, that they resembled these particular suspects, that the primary identification of a witness was a person who actually identified another suspect a year before that and then was never able to identify one of the suspects here. So her credibility is at issue.
That's not true. Don't forget that Norwood, Norwood in the police interview, was caught calling his mother and saying that he was involved in the incident and that he knew he was going down. Not only that, but he comes into the car with blood on his hands. You've got a whole bunch of witnesses that have identified these two guys acting like thugs, looking for a fight from the very beginning of the game. So identity will not be the defense. So don't go there. If there's a defense, it's going to be whether or not they committed the crime, because there could have been a crowd around them. But I don't even think that's going to stand.
And Chip,
because of the fact that
let me ask you about that part. The eyewitness that we're talking about, Mary Dolores Donnelly, she was at the opening game. She heard what she describes as people exchanging words and a scuffle ensuing, and she went towards what was happening, and she said that she heard Brian Stowe's head hit the concrete. I mean, but the scene that she's describing is a little bit different than maybe has been portrayed in the press of Brian Stowe and his friend being jumped and not really engaging with the said accused men. Does that change things at all? Because she says that she heard these guys exchanging words and a scuffle happening, and then eventually these terrible injuries, of course.
Well, as a matter of fact, it changes everything. The question to me, though, is, does it matter on identification? It absolutely does. She says she never saw them originally hit him and causing him to go down. It was only after they down. She said that she could only identify from a police lineup a year later after a wrong identification Sanchez, and she could never identify Norwood in a police lineup. Again, what the prosecution has to prove is somebody actually did this crime to this individual and not people just resembling these other individuals. There were hundreds of people that look like these two suspects that were out there. And so the question is right now, can we rely upon one person? The number one reason why innocent people in the United States are convicted is because of witness identification. And we know that from DNA technology now. And once a witness says somebody did it, they just don't back down.
So that's with your analysis.
All right, Donald, quick final thoughts.
Because that's the problem in this case for the prosecution.
Aiding and abetting, accessories after the fact. You've got all ways of getting these guys convicted. They don't even have to be the ones that actually kicked and punched this gentleman, although we think that they did, and the evidence shows that they did, but they clearly were aiding and abetting. So it's a slam dunk case for the prosecution.
Well, we'll see where it goes from here. Again, the 5th day of preliminary hearings, and it's certainly a man whose life is forever changed because of what happened at the park that day. Gentlemen, nice to have you as always. Thank you so much.
Thank
you.
Some are calling it the church's fight for freedom. This week, 43 Catholic institutions filed federal lawsuits against the Obama administration over regulations that would require them to provide coverage of contraceptives in their insurance plans, despite the church's teaching on that issue. How far will those lawsuits make it, all the way to the Supreme Court? Well, let's talk about it with trial attorney Chip Merlin and family law expert Sharon Lyko. They are here to break it down. Thank you to both for joining us today on this debate.
Good afternoon.
All right, Sharon, I want to start with you. What do you think about the potential for success on this particular? There are 12 lawsuits, 43 plaintiffs. It's obviously a very coordinated effort here.
Right. I think they're going to lose hands down. It's fundamental with the way that First Amendment attacks are analyzed by the Supreme Court that if a law is generally applicable, meaning it applies to everybody, and that it's neutral, it's not singling out a particular faith, it is going to withstand the attack that it's unconstitutional. And that's what's going to happen here. We've had many cases where religious groups have asserted that their religious convictions are being violated because, for example, American Indian couldn't smoke peyote at a religious ceremony. You've got Mormons where polygamy was banished in this country. You've got people that have to pay taxes, and you've got religions that oppose taxes which go to finance wars. Pentecostals, Mennonites, Quakers. That's all withstood attacks to the First Amendment. So I think that the Catholics are going to lose hands down.
All right, Chip, I want to bring you in on this. And what about that? The fact that the Supreme Court has recognized that they can't stop every law that may infringe in some way on a particular religious interest.
Well, that's absolutely right. And what she's saying might have been right up till 1993. That case she cited was a 1990 Supreme Court case. In 1993, Congress passed a law which indicated that if they make a law which somehow burdens an individual's rights and belief, the federal law then has to show some compelling interest and do so in the least intrusive means. And in this particular case, especially in the Notre Dame lawsuit, when you read it, Notre Dame points out that there's thousands of health care programs that are completely exempt because they're grandfathered out. And all kinds of other religious institutions are also exempted out. But they picked on the Catholic educational system, the Catholic hospitals, charitable organizations, in particular, in that the Obama administration broke this 1993 congressional law. And as a result of that law, this particular health care mandate cannot apply to Notre Dame and other Catholic institutions.
Yeah, and Sharon, what about that? Because we know there are some provisions, there are some exceptions built into these particular regulations so that there are some religious groups or ethnic groups that have objections who will be able to, opt out of these mandates. But, these Catholic universities and organizations say, we're not the church per se, so we are going to hire people who aren't, necessarily Catholics, but that doesn't mean that our mission should have to be changed by these regulations.
Well, their mission doesn't have to be changed. And the opt-out provisions that this attorney is talking about aren't going to apply here. It's a very strict application. They have to be hiring Catholics. They have to be serving Catholics. Has to be for a religious purpose. These are social institutions. You've got hospitals. You've got academic institutions. Not every religious conviction is going to withstand the attack from the First Amendment. Otherwise, the government couldn't rule. There are certain social policies that are going to override some individual's particular religious concern. And that's the way society has to function, or we're not going to function as a society.
And Chip, I want to give you the final word here. Why are the opt-out provisions not good enough for these Catholic organizations?
That's because essentially what they're mandating is that these Catholic institutions have now got to be placed in the very hypocritical situation of having a belief which they want to espouse to others, saying, we don't believe in contraception, we don't believe in abortion, we're not going to counsel, we're not going to educate people, but now we're being forced to pay people that are employees of ours to go get these very things. It really is a war on these beliefs and their educational values that they believe are fundamental with respect to their practice of religion. That's the reason why this case is an awful lot different based upon that 1993 congressional change. And the older cases, we don't have to look at at all. This is going to be a case fought on the 1993 Religious Reformation Act. So we'll see what happens on this.
Well, 12 different lawsuits spread across a number of different federal courts. We'll see how those courts interpret it. We'll see if any of them end up here at the Supreme Court. Chip Merlin, Sharon Lyko, thank you both very much.
You're welcome.
Well, happening now, the suspect in a 33-year-old murder mystery is reportedly on suicide watch. Pedro Hernandez is his name. He's expected to be arraigned today. Despite that, New York City police say he confessed to killing 6-year-old Eitan Pates back in 1979. It's still hard to see those darling photos of this little boy. Apparently, the confession says that Hernandez strangled this little boy just a few steps from his home. We're not clear on the motive. In fact, we're not clear on a lot of details on this except for the confession, which we're starting to hear more about. Former federal prosecutor Fred Teesey is with us, and defense attorney Chip Merlin, the founder and president of Merlin Law Group. It is hard to see those photos still. I mean, we've seen them so many times, Fred, and the loss of a child, it never gets any easier, even to talk about. And I just wonder for the family, what's going to happen next? I mean, what are the steps? We have a confession from someone, but as far as actual evidence, we don't know what we have. So what is next?
Well, we don't know what we have, Jenna, and you're absolutely right. You know, and if you've heard me say, I've got 4 sons. My youngest is 10 years old. I mean, I look at that picture and my heart just breaks for this family who never moved and never changed their phone number in case their little boy came back for him. But to answer your question, what's next is he's going to be arraigned on second-degree murder. And I've got a lot of questions about what's going on here. I mean, what physical evidence does the police have that corroborates this guy's confession? You know, what do they have that makes them believe that this isn't just some guy who's decided to confess to this murder?
And Chip, on that, you know, if you were the defense attorney, you know, and this was your client, is there even a strategy? I mean, do you just take this confession as the truth? Or are you also concerned that maybe this guy's some crazy guy that just decided that he's going to make this confession?
Well, confession might be good for the soul, but it makes the job of the criminal defense attorney very difficult. New York has a very interesting law, though. It says that a confession all by itself, without some evidence that an actual crime took place, is not admissible. Right now, there is no body, there's no corpus delicti, except for the individual's confession about how it happened. There is no physical evidence, and that confession might not be able to come to the courts in New York because of this very particular law that New York has.
So then what? I mean, then what, Chip? What does that mean? He would never have a trial?
No, that's the reason why the continued investigation is so extraordinarily important in this particular case. The police are going to go back after looking at the confession and see if they can find some type of corroboration that the way and the manner that this confessed murder took place actually did take place that way. Without it, that confession doesn't come in.
So, Fred, if the confession does hold up and there is somehow some evidence, and again, we have limited information right now about what that evidence could potentially be, what would this man face? Would he face the death penalty?
Well, in 1979, when the crime took place, New York didn't have a death penalty, as in a lot of other states would have been struck down after Furman versus Georgia. So I think that's off the table. And he's been charged with second-degree murder, which, unless the state can show that the murder was committed in connection with a sex crime or a rape or sexual abuse, and the victim was obviously under 14, then the charges, believe it or not, the penalties are 15 to 25 years imprisonment. So at the end of the day, you know, the state has to do more. And if you believe this guy's testimony, Chip raises a great point. I don't know how the state corroborates it. He says that he strangled the little boy, put him in a bag, and then disposed of the body in a basement that's been there for 33 years. I don't understand how the state corroborates that, and I think this is a tough case for the state to begin with.
So could he walk free, Chip, even if he has this confession that apparently is so thorough, but there's no evidence? Is that a real possibility that this man maybe never serves any time behind bars?
Well, it is a real possibility in this case if they don't find the corroborating evidence. And just remember, in the DNA evidence, which we don't have in this case, we have found that after false identity, the number 2 thing that people get off the hook off once the real DNA evidence comes in is their own confession. So this is pretty important. And the reason why New York law requires that there be some type of corroboration other than the confession itself that this is the way it happened.
Wow. Guys, it's so interesting. And you just, again, going back to the family, you just want some justice and some resolution for the family. And you wonder if they're really going to get it here or if they ever can. Fred and Chip, it's nice to have you. As we learn more, we'll have you both back. Thank you.